Hello and thanks for joining us on AIT's exclusive Law and Human Rights program, Project Justice. I am Utaba Umaran. This week, our focus is on electoral reforms. In particular, is the ongoing review of the Electoral Act 2010 by the House of Representatives. Last week, we gave you an update on that, but let's quickly remind you of the provisions in the amendment bill that is at public hearing stage. A bill for an act to make provision to cover the lacuna in the event of death of a governorship candidate any time before the conclusion of an election. Also, there is a bill to amend the Electoral Act 2010 to empower election tribunals and courts to declare candidates who scored the second highest vote as winners of election when the tribunal or court finds or holds that the winner of the election is unqualified for the election ab initio. A bill for an act to ensure that all political parties are gender sensitive and to eliminate all forms of discrimination in all political parties. A bill for an act to include the use of the card reader as part of the act and clearly specify the tenure of the office of the Secretary of INEC. A bill for an act to increase the amount permitted as maximum election expenses to be incurred by candidates standing for elections. A bill for an act on nullification of election by tribunals or courts and for other related matters. A bill for an act to amend the Electoral Act 2010 to make the electoral process foolproof by making the card reader the credible means of voter accreditation and voting, and provide for strict compliance with election guidelines and manual so as to enhance transparency and efficiency in the conduct of free, fair and credible elections. There has been high-level engagement on the proposals. Featuring on Project Justice this week is one of Nigeria's brightest legal minds. He has been involved in numerous election and petition matters spanning a couple of decades. He led the legal team that secured the landmark tenure judgment involving former Governor of Anambra State, Peter Obi, at the Supreme Court in 2007. Well, recently, he has been involved in high-profile election matters that has helped shape Nigeria's electoral jurisprudence. Dr. Onyechi Ikpeazu, Senior Advocate of Nigeria, shares his thoughts on some aspects of the proposed amendments from the hypothetic perspective of its practical application and lessons from the deficiencies of the extant 2010 Electoral Act.
Well, there are quite considerable deficiencies, especially in the area of accreditation, registration of voters, and the party structure, the attempt by the legislature to go into the realm of intra-party matters so as to effectively set the pace for what is generally classified as internal democracy within the party.
Well, stay with us for the full interview that comes up in a moment. Now, on Monday, 29th May was commemorated as Nigeria's Democracy Day. It is a day of reflection on Nigeria's democratic progress since 1999. Acting President Professor Yemi Oshibajo, who presented the Democracy Day broadcast to Nigerians, touched on a few issues that cut into the focus of this show. That has to do with the fight against corruption and the judiciary. Take a look.
In the fight against corruption, we have focused on bringing persons accused of corruption to justice. We believe that the looting of public resources that took place in the past few years has to be accounted for. Funds appropriated to build roads, railway lines and power plants, and to equip the military that have been stolen or diverted into private pockets must be retrieved and the culprits brought to justice. Many have said that the process is slow, and that is true. Corruption has fought back with tremendous resources, and our system of administration of justice has sometimes been slow. But the good news for justice is that our law does not recognize a time bar for the prosecution of corruption and other crimes, and we will not relent in our efforts to apprehend and bring corruption suspects to justice. We're also re-equipping our prosecution teams, and part of the expected judicial reforms is to dedicate some specific courts to the trial of corruption cases.
The speech notably was missing in several related issues where the administration has been very deficient. If democracy is all about basic freedoms, freedom to worship and freedom of speech, which includes criticism of political leaders, if democracy involves civil liberties, human rights, the rule of law and justice, how then will such vital elements be missing on a Democracy Day speech? Nigeria's human rights record since the coming into existence of this administration has received a serious hit globally. Court orders have been flagrantly disobeyed, with citizens' homes raided in Gestapo military manner, citizens arrested and locked up while security agencies embark on a voyage of discovery of evidence. This has been the trend not just at the federal level but also at the state. A viewer described the Democracy Day speech as, quote, intact, politically correct and intelligent, but vague and ambiguous. It is called a midterm report, and the acting president has said the administration will learn from its mistakes. Perhaps that includes the human rights and rule of law blunders. Let's now serve you with some of the top stories of the judiciary for the week.
Two men responsible for the wrongful invasion of the residence of Deputy Senate President Ike Ekweremadu have been charged before a magistrate court in Abuja. One of the suspects, Maiwada Adamu, is at large, while his co-accomplice, Ahmed Achoda, was in court. The first information report filed before the courts accuses the suspects of misleading the public by giving false information. The magistrate, Umar Kagarko, refused the suspect's plea for bail on grounds that it will be premature as his co-accomplice is at large. The case has been adjourned till June 5, 2017. There was a mild drama at the ongoing trial of Supreme Court Justice Sylvester Nguta when the exhibit of monies recovered from his residence indicated a shortage in the amount earlier declared. While the prosecution had claimed to recover 35,358,000 naira in local currency, a recount ordered by the courts indicated about 22,160 naira was missing. The exhibits were tendered by an official of the Department of State Service, John Utazi, who was among the agents who raided Justice Nguta's apartment. Former Attorney General and Justice Minister Mohammed Adoke has commenced a legal challenge of his prosecution over his role in the controversial Malibu oil block deal. Adoke, who has refused to return to Nigeria since the inauguration of Buhari's administration, has a pending criminal charge against him before the Federal High Court. However, his lawyer has filed a suit to assert his innocence, claiming that the former Justice Minister only acted on the directives and approval of the President, Goodluck Jonathan.
You're still watching Project Justice on Africa Independent Television. Let's talk law reform now, specifically the review of the Electoral Act 2010. We told you last week we'll be taking up analysis of the proposed amendment, the 12 bills on the review of the Act. My guest, once again, is a legal scholar and practitioner, Dr. Onyachi Ikpeazu, Senior Advocate of Nigeria. You've talked about the role of the legislature in legislating for the political parties. What limitations are there for the legislature in going to that? Because we've heard a number of times, even the court have said there are certain areas which they don't go beyond as far as internal affairs of political parties are concerned.
Well, let me take us back to the Electoral Act of 1982. Under that dispensation, the political party was supreme, essentially. And that took its cue from the common law rule that if you have voluntary associations, just like a political party is, then the court should not interfere in the internal affairs of that party. There was a very famous case during that dispensation, the case of Onuaha versus Okafor, which is the landmark decision in that regard. In that case, somebody went to court trying to challenge the primary process of the party, essentially asking the court to determine that he was the candidate of the political party. And the court, employing all the age-long cases, such as the ruling Fox versus Harbour, came to the conclusion that the court system should not really interfere in the internal affairs of the political party. But from then we have seen a gradual progression away from that dispensation, which I felt should have been ideal, to a point of the legislators now legislating for the political parties, dictating the pace for what must be embodied in not just the constitution of the parties, but indirectly compelling them by by law to comply with certain conditions. And I believe that that has taken the issue away from the dominance of the political party to a point now where the political parties are limited as to what they may do. So that area is quite worrisome.
But if you say we leave it to political parties to determine, we've seen how certain political parties have not acted very responsibly in situations like this, especially where you have a chief executive, for instance, who is interested in contesting for elections. The delegate list is very important. Who make up the delegates is very important. And they've taken, several steps to create some misdemeanors and manipulate the process to get themselves through. Don't you think it's an attempt to kind of sanitize the process and enthrone what so many people have always been talking about, internal democracy in political parties? Because if political parties are the basis for which individuals or public officials, elected officials are elected into government, the process should be sanitized, I suppose.
Well, to some extent, I agree with you, but the situation is that we should allow the system evolve and correct itself. Take, for instance, where in the primary process, a political party took certain steps by projecting an unpopular candidate who obviously would have lost the primary election. The electorate naturally should move away from such person imposed on the political party. And if we had allowed that situation to prevail from one dispensation to the other, the system would have corrected itself. But what we now have is members of the National Assembly that were somehow, one way or the other, affected by certain decisions of the party executive. Now they take it upon themselves to instill certain impositions, this time in the law, in order to cure situations which they fell victims of. Take, for instance, the first time this Section 34, the old Section 34 was introduced to require cogent and verifiable reason. We created a monster which ended up in the case of Amechi and INEC and the rest of them. So the ultimate result in Amechi and INEC might well be satisfactory. But we must remember, if you read that case carefully, that Honorable Justice Oguntade outlined 10 reasons why the Supreme Court was compelled to adopt such drastic measures. But we now subsequently took it as a rule that it is the political party that contests election, which is not true. But again, the Supreme Court, in some cases, CPC and Ombugado, for instance, categorically stated that political parties don't contest election. They canvass for votes on behalf of candidates, that candidates actually contest elections.
But we still don't have an independent candidate in our law, it doesn't still mean that the political parties still remain the primary vehicle for which candidates can get into political office?
That is absolutely correct, but we have multi-party system whereby an unsatisfied candidate, dissatisfied candidate, can easily move to another party and then seek emergence. And if he's really a popular candidate, then certainly the effect will be seen on the election process. For instance, take the American system. The Republican Party, in as much as they never really appreciated the antics of a Donald Trump, they knew of the consequences of him turning to become an independent candidate, just like Ross Perot did some years back. And really, with a viable candidate turning an independent candidate, it could be worrisome to the established political systems. But in Nigeria, really, we have multi-party system. And I believe that we cannot legislate everything. We must allow the system evolve. Evolve through case law, through hard experiences by the political parties themselves, so that they'll correct themselves and keep the system sane. No political party, I believe, would want to lose elections. So if propelled by that competition in a serene environment, then naturally the political party will internally correct itself in a situation like this.
Now let's look at another aspect to the amendments, which is part of the 12 proposals for the House of Representatives. You were part of the Rivers and correct Rivers governorship election. We saw what happened all throughout the court process up to the Supreme Court. Have we gotten to that stage where we can really legislate on this as well and mainstream it in the electoral act and make it a compulsory component of the elections as well?
Well, first of all, I'm happy you brought this issue up, because that card reader issue in the last dispensation is really a very simple matter. But perhaps because of the technology involved and the expectation of the petitioners, they made a huge mountain out of nothing. The decision of the Supreme Court, if properly understood, is simply this: that by virtue of Section 49 of the Electoral Act, the issue of accreditation had been statutorily determined. And that determination is that an intended voter must present himself to the presiding officer with the card, and upon verification of the particulars in the voter register, the presiding officer, upon satisfaction, will indicate that the person actually had a right to vote. That would be accreditation. Manual accreditation. So what the Supreme Court is saying is this: that for there to be an alteration of that situation, that there has to be a statutory amendment, because the card reader, as lofty as it is and has always been, because certainly it aids in the process of accreditation, is essentially an instruction and directive at an election. And we know that by virtue of Section 138, subsection 2, for instance, it says an act or omission which is contrary to an instruction at an election, but which in itself is not contrary to any provision of the Electoral Act, shall not be a ground for challenging an election. So if that is the case, it then means that inasmuch as the card reader did not form part of Section 49 of the Electoral Act, that non-compliance with that card reader cannot on its own be a ground for challenging an election. Now, that was the decision of the Supreme Court. And that decision of the Supreme Court had always been the position of the Supreme Court. If you go back to Buhari and Obasanjo, the first Buhari and Obasanjo case, in that case, what INEC did was they came up with a system whereby somebody was entitled, a voter was entitled to vote upon presentation of his voter card, regardless of whether or not his name was in the register. And the Supreme Court held no way, that there must be compliance with then Section 41 of the Electoral Act.
2002 Electoral Act.
Yeah, 2002 Electoral Act. And that is that the card must synchronize with the details in the register, and you cannot dispense with the register. So all the Supreme Court did was endorse their previous decision, and for some reason or the other, it evoked a lot of controversy, as if they came up with new law. It wasn't new law, it had always been there. And that decision was certainly consistent with Section 138 of the Electoral Act. But what they have now done in their proposed amendment is to bring card reader accreditation within the context of Section 49. And they did a very smart thing, because they gave the INEC an option, in as much as the card reader had been instilled. They gave the INEC an option of allowing manual accreditation to some extent upon the failure of the card reader system. That extent is this: that where those accredited by manual accreditation isn't more than 10% of the registered voters in that particular polling unit, then that will be fine. But where they exceed, the number exceeds 10%, then the election will be suspended and a fresh election held 7 days later from that date of the election. And I believe that this is a very clearer system. It may not be very perfect, but at least it's a clear system that will ensure that technology is brought in. And being brought in, it is also part of the act itself.
But are we really ready for such technological innovations in our electoral process, considering where we are in terms of, awareness, in terms of how really technology works in our climate?
Yes, as you know, I believe it's Section 53 of the Extant Act specifically abolished electronic voting. But happily, in this proposed amendment, they have allowed electronic voting. Can we
construe it as electronic voting or electronic accreditation?
Well, card reader system is electronic accreditation, no doubt. But there has always been a total abolition or proscription of electronic voting. But in the proposed amendment, they have an electronic voting in Section 50, either 52 or 53, I believe. So, and they also are doing a smart thing in that regard, because they have allowed INEC the latitude of either employing the electronic voting system or any other system it finds expedient. Now, the good thing about it is that where electronic voting doesn't work for one reason or the other, for the same fears that you are expressing, then they can always resort to the voting as we now know it.
There are people looking back at the preparation to the 2015 election who felt card readers were made easily available to people in certain parts of the country and not available in some. The card reader machine worked tremendously well in some parts of the country and didn't work in some parts, based on whatever permutation they may think was a reason behind that. But if we come to adopt this kind of amendment, which a lot of people believe would help sanitize the process and help it to be credible, is it not possible for that to be manipulated based on certain interests? And how do we deal with that moving to an election petition, where INEC picks and chooses, for instance, where this process works and where it doesn't work?
Well, that happens to be my problem with a system which is optional. But again, if you are about to introduce a highly technological system like the electronic voting in a society such as Nigeria, in order to prevent a complete collapse of the election process, then certainly there ought to be a window until such time as we can have a near perfect situation. There will always be manipulations. You're aware of the Bush versus Gore situation, for instance, the hanging child or the child that never went through properly. Now, such things must happen. But if we have a system that can be technologically approved, then certainly I believe some of these problems and human agencies could be minimized, if not totally obliterated.
Let's quickly talk on the amendment to the Act has to do with the death of a candidate in the process. That has been proposed as well. We saw what happened in Kogi State. What lessons have we learned from that?
The proposal they have sought to introduce, if there is such occurrence, then the situation will be suspended, the election will be suspended, and the political party will be allowed 14 days to do primaries, and then their candidate will start from where the last one stopped. I believe that again is not democratic. If there is no announcement of results, then the election process had not taken place. And if the election process is still inchoate, then you should do nothing. For instance, if there are 4,000 polling units and results were announced with respect to 3,900 polling units. Then you have 100 polling units where another candidate, a person who never secured votes for the 3,900 polling units, will now emerge, conduct election, contest for election in just 100 polling units, and then he becomes the governor of a state. To me, that is still not democratic. I believe the proper process should be, if the election process is interrupted at this crucial stage, in as much as nobody had emerged victorious, the entire system ought to be aborted, and there should be a restart with a new candidate who emerged from the primaries, going back to start. Absolutely. Now, there's also one area which to me is quite worrisome. That is the area of proof. As you well know, there is a problem of proof always. Documents will be tendered, and the tribunals and then the courts will arrive at the conclusion that those documents were tendered, sufficient witnesses were not called to give evidence. In other words, that mere tendering of documents will not suffice.
The witnesses are supposed to speak to the documents.
Absolutely, but what they have now sought to introduce is a situation where if certified results are tendered, then they are prima facie authentic, and then the burden will be cast on the other side. The problem with that is that they don't have the capacity to dictate to a court on how to arrive at a determination. By then, they would have gone beyond the realm of legislating and gone to the area of judiciary. So such sections may be liable to being set aside. So they need to be very careful in that area specifically.
Stop it here. Thank you so much.
Thank you. Thank you.
Thank you.
Very grateful.
Our subsequent episodes will take up other components of the amendment bill. And that's Project Justice this week. Do remember to follow us on Twitter. Our handle remains at ProJustice Live. Also like ProJustice on Facebook and view us on YouTube as well. On behalf of the entire production crew, I am Utaba Umaran. Thanks for staying with us.